Divine Mercy and Radio Television, Diocese of Buea. Once again, welcome to another edition of You and the Law, presented by me, your host, Reverend Father Barrister Emil Tanka. We are happy today to be again with you. We thank you very much for always watching Divine Mercy Radio and Television of the Diocese of Buea. Thank you very much for being there. Once again, we are here live with Barrister William Ateba Marafa. Barrister, you are welcome as a host.
Oh, thank you so much. Thank you so much, Council. I'm happy to be a part of this program today.
When I learned that such a program is a going concern where the media is taking active steps at educating the population at large, the Cameroonian people at large, on these fundamental issues of law, I was more than impressed, because I think that such programs are very much essential, especially in our context of Cameroon today, as this will help to counter this problem we have of lack of awareness of the law. Now, thank you once more, Council, for this invitation.
Thank you, Council, for coming. Last week we were here. We were on the various courts. We're talking about the various courts in Cameroon. The courts as provided for, particularly in the amended Constitution of 1996, particularly Section 26, Paragraph 5, whereby the legislative arm has power to create of the judicial organization and also for the creation of courts. And with the law of the judicial organization, which we have the law on judicial organization amended and supplemented of 2011. So Council will just give to the public a highlight of the courts, the various courts again in Cameroon. Will just remind them, the public. Thank you.
Oh, thank you once more, Council. As Council has rightly noted, under the Cameroonian law, we have a number of courts which have been put in place to enforce and to interpret the existing laws. And these courts include, you have the Supreme Court, which is the court at the apex, the highest court of the land. You have the courts of appeal, you have the High Court, you have the Magistrate Court, you have the military tribunals, you have the special criminal courts, and even the Constitutional Council. And these courts have been put in place by the Law of Judicial Organization of 2006. And one of these courts which I also did not notice, the Customary Court. So these are all courts which have been put in place under Cameroonian law to ensure that justice is accorded to the people.
Thank you very much, Council. I think that last time we dwelled a lot on the courts, but particularly want to pay attention today very briefly on the Court of Appeal and the Military Court, which we said very little last time because of time constraint. So particularly when we talk about the Court of Appeal, pursuant to Section 439 of the Criminal Procedure Code, talks about they outline the various persons who can appeal, particularly if you are not satisfied about a particular judgment that was given by a lower court. So you can appeal. And we talk about persons in law. There's what we talk about artificial persons and natural persons. Artificial persons can be companies. Artificial persons can also be even the government. The government is an artificial person, while natural person can be you. It can also be me, natural persons. So we are looking at the Court of Appeal. The Court of Appeal, particularly pursuant to Section 440, it actually outlines the time limit. Now, time, we talk about computation of time when it comes to law. Time is of essence. So you have 10 days when a judgment is given by a lower court for you to appeal. So if you do not appeal after 10 days, and in law, time starts running the following day. When a day is given today, for example, today being the 19th of June, then it will follow immediately. Time will start counting from the 20th of June. So if you are appealing after 11 or 12 days after that, then immediately the counsel of the opposing party, he can raise a preliminary objection that you are appealing against, you are already against time. So then you look at it also when it comes to default judgment. And what is default judgment? When a judgment is given by a court where one of the parties is absent, or one of the parties did not show up, or one of the party did not actually fail to take the matter serious, and he is absent in court. So a default judgment will be given. And so when the default judgment is given, then time will start running from when the judgment is served to the other party. When the judgment is served to the other party, it can be monetary terms that he has to pay a sum of money. It can be that the judgment has to be enforced, whereby the military or the police, they can ask them to enforce the judgment. So I think also that is when it comes to the Court of Appeal. Yes, and again we'll talk about the military court. Yes, the military court. The military court is clearly outlined pursuant to law number 2011/012 of 12 July 2017, whereby the Code of Justice is given that in every region there should be a military court, particularly in Buea, where we are. In Buea, the military court, we have the military court around where they call the brigade. So where you take a taxi, say that you're going to brigade, that is where the military court is found, directly opposite BHS, the Baptist High School. That is where the military court is found. And in section 9 of this particular law, it says that in section 9 of the Constitution and in section 4 of this particular law of military justice, it says that the military court in Yaoundé has jurisdiction to try offenses such as serious threat to public order and state security, or also act of terrorism that is exercised nationwide. If this act threat to security, threat to public order, act of terrorism, if these acts are being committed anywhere in the country, then the military court in Yaoundé has jurisdiction pursuant to section 4 of the 2017 law of the Code of Military Justice, and also pursuant to section 9 of the Constitution, 1996 Constitution of Cameroon, as amended from the 1972 Constitution. And also crime against humanity and genocide, the military court has a right to try it. So counsel, when it comes to military courts, yes, we think that when it comes to military court, also who are those who can be tried in military court? Those who use arms, like the military arms, they use it to commit a crime. That if somebody uses a gun in committing a crime, he will be tried in the military court. If someone uses or someone sells military weapons or is doing trading with military weapons, anything that is concerned with military, and also those who are working in the military, like the cooks, like the secretaries, they can also be tried in the military court. But minors of age below 19 years who are either offenders or co-offenders or accomplices, they cannot be tried in the military court. But also we must also know that pursuant to section 13, paragraph 4 of this same law, the ministry in charge of military justice has a right to declare with the president to declare noli prosequi when it comes to a particular matter. When it comes to a particular matter that is going on, noli prosequi means that they have the right to stop a particular prosecution that is going on when they see the need of doing that before judgment. They can declare noli prosequi, they set the person free. Maybe they can still institute the judgment later on, but they can declare noli prosequi to cancel a particular judgment. The Ministry of Justice, and together with the president, they can do that. So counsel, straight away, I think that we should look at the court, the structure of the court. Let us look at the structure of the court. So, counsel, the setting of the courtroom. Yeah, thank you.
Thank you once more, counsel. It is very essential to know how the court is structured for a number of reasons, including the fact that when we know, or when the people know how the court is structured, we have a better grasp of how justice is done, how justice is being practiced or carried out in our courts, and the various parties who are involved in court proceedings and their rules. So looking at the setting of the court, or the courtroom setting, you have the bench, where the presiding magistrate or the presiding judge will sit, if you have one or more, where the seat is known as the bench, which is just an elevated area in front of the court.
And thank you very much. And counsel, you know that sometimes I talk about the bench, some people may be thinking that it's a fiscal bench. You know, or talk about the bar, they may think that maybe it's an off license where you go and buy drinks.
Yeah.
You know, yes, it is clear that it's not a physical something there. Yes.
Yeah, so that elevated area where you have the presiding judge or the presiding magistrate sitting is called the bench. Then immediately in front of the bench you have where the registrar of the court sits. So the registrar sits. The registrar administers and helps the judge or the court to administer justice, maybe by reading out the case to be heard or the cases to be heard, and helping the parties to administer their oaths and so on.
And thank you very much, counsel. You know, as you are saying, particularly in front of the magistrate or the judge, you have there, as you said, the elevated section there is for the magistrate, and the lower section, you know, also for communication, so that the judge or the magistrate can easily communicate with the registrar, and then the registrar, not only the registrar can be the interpreter, the interpreter can also be there, the court clerk, they can also be there. Thank you very much, counsel.
So you have that, and then just right in front of the registrar, you have the bench. The bench is where you have, rather the bar. The bar is where you have the lawyers, where the lawyers sit. And this in Cameroonian context, you have both the lawyers and the state councils, since they are both councils. So they sit in front of the registrar, and that area is known as the bar. Then at the right hand of the judge, you have the witness box, where those who come to court to testify, are put in before they can give their testimony in court. Then at the left hand side of the judge, you have the dock, where the accused person is put and will be examined and examined in chief, cross-examined and re-examined.
So we have the dock right there. You can see it, D-O-C-K. The spelling is there. You have the witness box is there. Okay, thank you.
Yes, and then you have the gallery.
Okay.
You have the gallery too. The gallery is for the public. You know, oftentimes, except in some exceptional circumstances, the public is allowed to come to court, because justice in Cameroon is done in the name of the people. So the people are allowed to come to court and witness how proceedings are being carried out. And this is done in a bid to foster justice, and at least to demonstrate to the people that the fairness of the court, the independence and impartiality of the court. And that is how it is done. So the court is an open place oftentimes, except where maybe for public order or some other reason, maybe the case of a minor being tried, you have such proceedings being held in camera. But oftentimes, court proceedings are done in public, so everybody is free to go. And where you see it as a public is known as the gallery, as it has been shown on television.
So thank you very much, counsel. You see, I mentioned the word there. You know, they said this program is that we help people to understand very well. So proceedings are held in camera. So, counsel, what do you mean by proceedings?
Proceedings are held in camera means they are not open to the public. Okay. At times, proceedings can be, the public can be barred, like I noted, from witnessing the unfolding of proceedings in court. The general rule is that proceedings are held in public. That's why we have the gallery, for the public to come and sit and witness how proceedings are being conducted. But in some cases, you have, maybe in case of public order, or where it is necessary to do so for the sake of justice, and where the law has so required, some proceedings might not be done in public. And I've cited the proceedings where a minor is charged with an offense. In such a case, for example, the law demands that he or she be charged or be tried in camera. So you cannot put such a person, a minor, in public. So in camera means out of the sight of the public. It could be in the chambers of the magistrate or the judge, as well as it could be anywhere where you don't have the public partaking.
Okay, thank you very much, Council. That's a beautiful one there. You know, as you said, the gallery. I remember this word we were in school, talk about amicus curiae, where the amicus curiae could sit, and also where lawyers who do not have to make appearance, they can also sit. And particularly in court, sometimes we have a special place for the policemen, where sometimes they sit, if or the warders. Yes, whenever they have brought in maybe a prisoner, they can have a seat. There's some special seat for them. And it is good for us to note that in Cameroon, the court of first instance, barristers are not robbed. They are not dressed in their legal regalia. They are not dressed in their legal regalia. But when it comes to the High Court, they are dressed in their legal regalia, particularly in Cameroon and other courts. And Council, what again can we tell the people when it comes to court proceedings, like when the magistrate have to enter the court or the judge is entering the court, the reverence that is given to the court, when it comes to the reverence given to the court? I know that is linked to contempt. You know, we talk about the reverence given to the court and it is not given, then we have contempt. So, Council, what do we have to say concerning that?
Yes, you know, we have to give the court its place and its dignity. The court is the very temple of justice in every just society. So it is very essential to ensure that the court be clothed with its dignity. So in case where a party or anyone interferes with the dignity of the court, that person could be cited for contempt and be penalized according to the existing laws or in accordance with the existing laws. So the court is the temple of justice, and its orders, and not only its orders, even every effort the court makes in its pursuit for justice must be adhered to. So going to court and acting in a way which is not in accordance with the manner in which you should act in relation with the court can end you can put you in a situation where you could be cited for contempt and penalized accordingly. So that's just contempt of court. Contempt of court can be defined as maybe any willful interference with the court's ability to administer justice. When there is a willful interference with the court's ability to administer justice, maybe you go to court and you become rowdy. You could be cited for contempt, and contempt also includes those conducts or words or even your omissions which threaten the dignity of the court. So if you act in a way which threatens the dignity of the court, or you utter words or even a word that threatens the dignity of the court, or even your omission when you're maybe invited to court to testify and you fail to do so, when you
could be cited for contempt.
You could be cited for contempt.
Yes,
so
yes.
It's not all about your actions or your words, even your omissions.
Every omissions also, yes.
Citation for contempt.
You know, even in the church, we say for what I have done and what I fail to do. You know, that's the sin of omissions. And the court also has its dignity that must be maintained. For example, when you are addressing the judge, there's a particular way in which you have to address the judge. And as you rightly said, the judge or the presiding magistrate has an elevated position which is called the bench. That elevated position puts him in control, that he is in control, and quite often he is referred to as the court. The same also the bishop of the diocese, the bishop of the diocese is referred to as he is the church. So the same also in court. So when the presiding magistrate enters, if it's about entering, as he's entering, everybody rise. Yes, everybody in court. So, and when he sits, everybody also sits. Yes, everybody sit down. So thank you very much as we look at that. Also, the contempt is particularly spelled out in section 152 of the Penal Code, where it says that any defamation, abuse or threat conveyed by gesture or cry even uttered by anyone, you can be cited for contempt in court. And pursuant to section 303 of the Criminal Procedure Code, of Cameroon Criminal Procedure Code, says that the presiding magistrate or judge shall ensure and maintain order when it comes to court. So if the magistrate or the judge asks you maybe for something, or asks you to leave the court, or asks you for, or asks that something is not going on well and it is not maintained, he has the power, because at that particular time, doing as the law says, particularly pursuant to section 303, the law says he shall have the force of law and order for the duration of each of the session. He has the force of law, so there he can cite anyone. And so that is the reason why, also pursuant to section 306 of this same Criminal Procedure Code, which says that it does not allow for any recording. You cannot go to court and start recording things like that as they are happening, or taking pictures, or you are allowed to do certain things. But that particular act is punished under Cameroon law of the Penal Code 196 paragraph 2. Yes, it is punished, and your items, your phone, or whatever thing you are using to record, it can be confiscated, provided for in section 35 of the Penal Code. You can be sanctioned and can be seized from you. So you go to court, you don't need to remove your phones and start taking pictures or start doing other things that is not good. In fact, the judge or the magistrate require attention, and if you do not obey, you will be booked down for contempt. And yes, punishment that is given, as I said, from section 198. So thank you very much, counsel. Then what again do we have to say when it comes again to contempt of court?
Thank you once more, counsel. In addition to what you have rightly noted, I just wish to point out the fact that, like you have said, contempt of court is provided for under section 154 sub A of our Penal Code, and this should be read in
conjunction.
In tandem with section 152 of the Penal Code, which actually defines what contempt is. Yes. But it is worthy of note that the definition of contempt in our Cameroonian context, especially in our criminal justice system, is quite distinct from the definitions provided for under some other foreign legislations. Contempt within the Cameroonian context, especially the Penal Code in particular, it has to do with, or is concerned with, such words or conduct which are uttered in public or intended to be public, which tend to defame, to abuse, or to threaten the court. That is summarily put, it has to do with scandalizing the court. So if you make or you utter words or you behave yourself in a certain way that is intended for the public or is done in public with the intention to defame or to abuse or threaten the court, that is what will amount to contempt of court in the Cameroonian context. Then what then becomes of such instances where you do not utter a word or you conduct yourself in a manner that in public or intended to be public, which defames, abuses, or threatens the court? What if you're summoned as a witness and you fail to come? In other jurisdictions, you could be cited for contempt, but that is not contempt within the Cameroonian context. So contempt in the Cameroonian context is strictly limited to the meaning, or within the meaning or the confines of section 154, read in tandem with 152 of the Penal Code. So such acts which are contemptuous acts, but which do not fall under this definition of contempt within the confines of 154, read in tandem with 152, are separately criminalized. For example, you have section 173 of the Penal Code, which criminalizes defaulting witnesses. If you are summoned to court to come and testify and you fail to do so, or even if you come to court to testify, a question is put to you in case of a felony or a misdemeanor, a question is put to you and you refuse to answer it, you are a defaulting witness. In some, yes, this is contempt of court, but this is not contempt of court within the meaning of 154, read in tandem with 152. So this is why the legislator had to go a step further to criminalize such other contemptuous acts which do not fall within the contemplation of 154.
Thank you very much, Council. And as you said, there rightly said, particularly Section 198, Paragraph 2 of the Penal Code, which clearly spells out a punishment given by somebody who deliberately, intentionally publish proceedings or publish some part of deliberation, of court deliberation, either in the chambers or in the court, that they will be punished with a fine of 10,000 to 3 million if you record and publish it. And that in case of a print media or of any house or radio or television, the penalty will be doubled, which means that if you were supposed to be fined with 3 million, you'll be punished with 6 million. That is what particularly Section 198, Paragraph 2 of the Penal Code, Cameroon Penal Code, is saying. And as you rightly point out, the contempt is being punished according to different categories and different degrees. But all is that respect should be given to the court. Respect should be given to the court. And how do we address the court officials?
Okay, it is very essential to know not just the law, but how to address the various officials of the court. So, when dealing with the judge, or let's begin with the magistrate court, which is the court of first instance, rather. It's presided by a magistrate. So you either call or you address the magistrate, the presiding magistrate, as Your Worship, Your Honor, or Sir. If you are in the High Court, you address the presiding judge as Your Lordship, My Lord, or My Lord. And this applies to even the superior courts, all other superior courts, the courts of appeal, Your Lordships, My Lords, and so on. For the courts of appeal and even the Supreme Court, then for the state councils, you call Sir. Or if you're practicing and they are not going, you call Sir. You refer to them as Sir or the learned prosecutor.
And some of the other officials also, because like the magistrate, they are addressed as Mr. Yes, Mr. The registrar, sorry, the registrar is addressed as Mr. The translator, Mr. or Mrs. Yes, you rarely address them like that. The registrar, they are addressed as Mr. or Mrs. Council, thank you very much for this wonderful thought out that we have here, which we have given to the people. They are out to learn a lot, and especially in the University of Buea, I'm greeting all the students in the University of Buea. They are particularly interested in this program. Yeah, some of them have met me and they are talking about it. I think it's a good program. I'm greeting all of them there. So, Council, any word for the public? Thank you.
No, I just wish to appreciate the public and to encourage the public to be interested and to follow up such programs, because they are very essential. They give you such fundamental issues of law, and they have to be taught to you, which cannot maybe be taught within the confines of our classrooms. So it's very essential to be a part of this program in one way or the other, or at least to follow up the program. Thank you so much for following up. Thank you.
Thank you very much, Council. Thank you for coming. We thank also the workers of Divine Mercy Radio and Television. They are always there. They are always working. We thank them very much. We also thank the proprietor of Divine Mercy Radio and Television, Bishop Michael Bibi. We thank him very much for giving us this opportunity to have this program live, Divine Mercy Radio and Television in the Diocese of Buea. Thank you all for watching, and we look forward again to seeing you next week. Watch out, next week, Monday, same time, 5:30 to 6 p.m. Every Monday. Make sure